Hello and welcome back to another video on A-Level Law. Today we're going to be talking about attempts, which is on the A-Level Law OCR specification, and it's on paper 1, Criminal Law and English Legal System. We're going to start by looking at the main law on this, and this is the Criminal Attempts Act 1981. Now this sets out the actus reus and mens rea for any attempt, so that could be attempted theft, attempted rape, attempted murder, it doesn't matter. And a classic mistake people make when talking about attempts is they stray into the areas of law. So for instance, if they're talking about attempted murder, they start talking about murder, so the Coke definition of murder and things like that. For instance, if they're talking about attempted theft, they might start talking about dishonesty, appropriating property belonging to another with intention and permanently deprive. All of that is irrelevant. For any attempted offence, you look at the Criminal Attempts Act and the actus reus and mens rea for an attempt. You do not need to look at the actual offence that is being attempted. You can ignore that per se. It's literally focusing on the attempt. So if we look at the Criminal Attempts Act, like I said, it sets out the actus reus and the mens rea. It's really important that you do include the Criminal Attempts Act in any answer you give, and particularly that it's capitalised, so criminal with a capital C, attempts, capital A, and act always with a capital A as well. The actus reus is fairly wordy, but what it is doing an act that is more than merely preparatory to the commission of the full offence. So what that basically means is you've move beyond merely preparing. You're not just preparing to do the offence anymore, you're beyond that. So it's that stage between being more than merely prepared or more than merely preparing and actually committing the offence. It's between those two things that is the actus reus, so that stage. And that can be really hard to work out in some circumstances, so you've got to just sort of look at the scenario and make a sort of gut decision based on the facts that are given to you. The mens rea is intention to do the full offence. So So for attempted murder, for instance, it's intention to kill, it's intention to murder, it's intention to do the full offence. For attempted theft, it's intention to steal, it's intention to do the full thing that you're wanting to do. So whatever the offence, it's just intention to do the full offence. So whatever it is, whether it's murder or theft, whatever it is, it just works out the same. The category and maximum sentence will depend on the offence being attempted. So we can't say, I could sit here and go through every single one, but I'm not going to. So it depends on whether it's attempted murder, attempted theft, etc. So largely speaking, in a scenario, you don't need to mention that. In terms of the actus reus, we're now going to look at, well, what does merely preparatory mean and look like? And I've got several cases here for you. You've got 3 cases which were deemed by the courts to be merely preparatory, so that was not an attempt because they hadn't done the actus reus. And I've got 3 cases that are more than merely preparatory, which were attempts because they had done the actus reus. So we're going to start with the ones that are merely preparatory, and remember these were merely preparatory, not more than merely preparatory, and therefore weren't attempts. The first one is Gulliver. Now Gulliver put a bet on a dog racing event. He saw that he was going to lose, so he jumped down onto the tracks and stopped the race. And the race had to be called off, and obviously in that instance people get their money back. He didn't, however, go and try and get his money back from the booth, so they said he hadn't gone beyond merely preparing, he hadn't moved beyond that stage, because actually to get to that stage he would have needed to go and try and get his money back. Actually just stopping the race, that was still in the merely preparatory phrase of attempted theft. It wasn't actually enough to be an attempt. If we look at Campbell, he was stood outside a post office with a fake gun and a threatening note which said something like, "Give me all the money," or something like that. And again they said this was merely preparatory, because they said for him to be more than merely preparatory, for him to move into that next stage, he'd have to have actually gone into the post office. So again, that was merely preparatory and not an attempt. Geddes, he was found in school toilets. He didn't work there, or he had no right to be there, and he had duct tape, rope and a knife on him, and obviously he was charged with attempted kidnap. And they said he was merely preparing because they said he would have actually had to have approached a child for it to move into that next phase of being more than merely preparatory. A bit of a weird case, but if you have a read up on it, it does make a little bit of sense, but it's still a bit odd, really. In terms of the cases that are more than merely preparatory, the first one is Jones. So in Jones, he got into the car of the victim with a motorcycle helmet on and a shotgun and pointed the shotgun at this guy, and they said that was an attempted murder, and they said that was more than merely preparatory because he'd moved beyond the stage of just merely preparing. Merely preparing might be getting the gun, going to the place. That was actually the fact that he got in now and pointed it at him, that was more than merely preparatory. In AG's reference, a man pulled a lady into a bush and tried to rape her, but he couldn't get an erection. And again, they said that was more than merely preparatory. He'd moved into that stage of just more than merely just preparing. He'd actually moved into the next stage, which was closer to actually committing the full offence of rape. And that really is a public policy case. There's no way that they were going to say that was merely preparatory because of the nature of it. So clearly is more than merely preparatory. And finally, Tosti and White, they were found examining a building and a door looking like they were going to break in, basically, and they were charged with attempted burglary, and their tools were down the road hidden in a hedge, and they said that was more than merely preparatory as well. Okay, so bear that in mind. That can often come up in a scenario. In terms of the mens rea, as I said earlier, it's intention to do the full offence. So you've got to intend to kill for attempted murder, to steal for attempted theft, whatever it is, you've got to intend to do the full offence. Recklessness is normally insufficient, as you'll see in Millard and Vernon in a second. Whybrow illustrates a nice case around attempted murder, and it has to be intention to kill. So in Whybrow, he wired up a soap dish intending to harm his wife and give her electric shock, and he was found in the case that he didn't intend to kill her, he only intended to do serious harm or something like that. So therefore, he couldn't be guilty of attempted murder because he didn't intend to kill her. So that sort of lays out that case. Millard and Vernon, there was 2 kids shaking a fence, and they were arrested for attempted criminal damage. And they certainly didn't intend to do criminal damage. They knew there was perhaps a risk of doing it and decided to take that risk anyway, which is the definition of recklessness from the case of Cunningham. But the court determined that recklessness is not sufficient for mens rea for attempts, so therefore it has to be intention to do the full offence, so therefore they were not guilty. When you're looking at the actus reus and mens rea, remember when you're applying this to a scenario, you have to methodically apply it, and I'll go through that in a second. But just 2 other things that you need to consider that could be relevant in scenarios are attempting the impossible and conditional intent. Now, attempting the impossible is laid out slightly in the Criminal Attempts Act, so it's worth having a look at that. But the 2 main cases I would really look at are Shifpiri and Jones. There was an older case called Anderson v Ryan, which now has been overruled by Shifpiri, so just bear that in mind. Shifpiri, he was charged with importing Class A drugs into the country. He was found with a briefcase full of white powder, and he said, okay, yeah, he put his hands up and said, okay, I'm trying to import cocaine or a similar Class A drug. And they said that, okay, they'll go away, look at it, and they tested it, and it turned out to be cauliflower powder and sort of white snuff, like nothing illegal or anything like that. So they were a bit of a predicament. He thought he was committing an offence, but he actually wasn't. So he was attempting something that was actually impossible, because it wasn't possible for him to be caught importing Class A drugs, because they weren't Class A drugs, but they had to decide whether he was guilty or not. Now, the old precedent I just told you, Anderson v Ryan, said that you couldn't be found guilty in situations like this, but Shifpiri was a House of Lords case, and they actually overruled that, and they said, actually, you can be found guilty. And interestingly, on a side note, Shifpiri was the first time that the practice statement was used in the House of Lords. So if you know anything about the practice statement, then that's a good example of that. If you're not sure, have a go away and have a look at it. It's a document that the House of Lords can use, or now the Supreme Court can use, to overrule themselves in certain circumstances. Jones was a similar case to this, happened a few years later after Shifpiri, quite a few years later actually, I think, and a policewoman was posing as a young girl, and a man was talking to her on the internet, and he basically tried to argue that he couldn't be guilty of attempting to solicit sex from this underage girl because she wasn't actually an underage girl, it was impossible, it was actually a policewoman, but they said no, you can attempt the impossible based on the precedent of Shifpiri, so he was found guilty. Finally, with conditional intent, and it's really important that you understand this because a lot of people get this wrong, AG's reference has overruled ESOM, but I'm going to include ESOM just because it is relevant and it can be useful for looking at facts, and they do like to talk about it in a scenario, so it's worth mentioning. ESOM, he was in a cinema and he put his hand into this woman's handbag to take whatever he could find, so on the condition he could find something, he'd take it, but he didn't find anything, so he did decide not to. And he was found not guilty of attempted theft because they said he didn't intend to steal anything specific, so there was a sort of a loophole there, which meant they couldn't say that you intended to steal something specific, they couldn't get you for attempted theft. Now that was closed by AG's reference, and AG's reference is a case they were sort of involved in. They were in a building looking for something to steal, essentially. That's all you need to know about the facts for that one. And AG's reference actually overruled ESOM and said you can be guilty of conditional intent. So if you're just because you didn't intend to steal anything specific, essentially, you can still be guilty, and that's called conditional intent. So you can refer to that in the scenario in the exam. But just remember that AG's reference is overruled ESOM now, so you can be guilty of attempting the impossible. Now in a scenario, it can come up by itself, attempts, or it could in theory be combined with another topic like murder or non-fatal offences. That certainly has been done in the past. So you just got to have a look at that and see what obviously is being demanded by the question, whether it is just attempts or whether it's combined with another topic. There is no essay required, as the specification does not require evaluation of attempts, so you don't need to learn any A3 for attempts. It's the only topic actually within criminal law that you don't. And then obviously make sure you apply the actus reus and mens rea methodically, reaching a conclusion, and consider attempting the impossible condition intent where it's relevant. So it's really important that you follow that test really clearly and apply the actus reus. Has the person in this situation, this scenario, done an act that is more than merely preparatory, and do they have the intention to do the full offence? So that's ticking off the actus reus and the mens rea. And make sure you're referencing what the actus reus and mens rea is, making sure you reference the Criminal Attempts Act, and making sure you're explaining why you're saying the actus reus or mens rea has been met. And also bear in mind that if the scenario makes reference to something that's impossible or something around conditional intent, making sure you're throwing those in there with reference to cases, relevant cases as well. And obviously making sure you reach a conclusion in the scenario. Thank you very much. I hope you found that useful. And if you did, please subscribe to this channel and look at some other videos on criminal law. And there'll be more videos coming out on tort law and contract law soon. Thank you very much.